want to make sure you focus on those things. And then I will note that item number 5 is being postponed, and item number 9 is being delayed. So on the motion to postpone item 5 and to delete item 9, comments or questions? Seeing none, all in favor of that motion, signify by saying aye. Any opposed? Those items are dispensed, so we will move on to then item number 1, 1100 Nicollet Mall. Mr. Scarda.
Madam Chair, members of the committee, this is a claim brought by 1100 Nicollet Mall LLP with a date of loss of February 11th, 2014. It has to do with damage from water. The claimant filed a claim for property damage on February 11th, 2014. There was a water main leak discovered in their private manhole located at 1100 Nicollet Mall. The claimant indicated the leak was between the main and the saddle. The claimant believed that the main settling most likely
Okay, so this is a fairly complicated sewer-related issue. Are there any questions for Mr. Scarda? Seeing none, we'll open the public hearing on item number 1 and invite the applicant from 1100 Nicollet Mall to come forward. Good morning.
Eddie, my name is Gene Purdy, and I'm the managing partner for 1100 Nicollet Mall Partnership. We do not claim any negligence, excuse me, by the city on this matter. It's more an issue of allocation of responsibility based on where the main broke or the break occurred between the main and our valve. And I believe the packet of information that was submitted to you has all the relevant documentation, photos, and information. And based on historical treatment of these types of leaks, it is our understanding that if the leak is on the side of the main from our valve, it has historically been responsibility of the city to make the repairs. And that's the sole issue that we're coming before you.
Okay. Mr. Purdy, you realize you have to prove the city was negligent, not the history of what we would potentially pay out. And
understood. And we've never claimed negligence on the city.
But that's the only way that we can rule that you would be correct.
We understand that. I think that the issue then for us is what's the appeal process for allocation of responsibility.
Like a subrogation issue.
Yeah, exactly.
Mr. Scarda, can you speak to that?
management or direction of this committee to negotiate with him about the process, or ultimately if he were to take it to conciliation court and either side, conciliation court or district court, and either side would present their arguments regarding the level of damages and how it should be apportioned between them.
So what Mr. Scarda is saying is we'd first have to find you negligent, or the city negligent, and then we'd have to discuss whether or not there were damages, just to be clear. So I would just urge you to give us any sense. The sewer people are going to get up and explain what happened. So why don't you step aside, and then you could contradict them if you want.
Fair enough.
Okay. Someone is here from our sewer department, correct? Please step. Yep. Please step forward.
Actually, I'm Madam Council Member and Council Members. Actually, my name is Mike Olmsted. I'm the General Foreman for the Minneapolis Water Department.
Okay.
We were called for a leak on this line, and there was water coming out of the manhole. So when we pumped down the manhole, it's an old brick manhole from 1910, it settled onto the main and broke the main. And it also did it in 2001. The first time originally was 2001, it broke the main. And then it did it again in 2014 in February. And so we notified, according to the city of Minneapolis, they own the manhole, the tap going from the main into the building. So that's where the leak was, is on their tap, were connected to the Minneapolis water main.
Okay, would you like to show a picture?
I do have pictures here.
And can you show where it would be private and where it would be public, just so everyone can get a sense of how we discern what is the public responsibility and what would be a private responsibility in a sewer or water main break issue?
Okay. How do you work this to pull the pictures up?
They're going to help you.
Well, that thing at the top of the picture is actually their valve going into their building. Running horizontal across the bottom is our water main.
Can you use a pointer? Even your finger? It's pen? Okay.
This is the, excuse me, this is the, oh, that one's not working.
That's all right.
It's working. It's okay.
This is their tap sleeve right here, and you can see the water spraying out from the tap sleeve. And the problem that they have with these old brick manholes is eventually these start settling, and this settles down onto the water main and pushes down with force on it, which cracks it. And this was originally cracked right in here in 2001 when they made the first repair on it. And here, I have another picture here of it. You can see the water spraying out right here from their tap sleeve right here. So,
So the water department has determined that this is a completely private portion.
yes,
Of
a
system.
building owner owns the tap and the manhole. And when the main is in their manhole, it's usually they cement brick around them, and that's what pushes the force down on settling after years. So that's what happened here twice.
Okay. Are there any questions for Mike? Councilmember Gordon.
Maybe you could put the picture back, because my question just had, can you show us where the part that the city owns and where it becomes privately owned?
Well, the city would own the water main probably up to here, but when it's in their manhole, that's still part of their connection, is within that manhole area.
So where the leak is they're responsible for it, but that's part of the main?
Well, this is part of the main, but you can see the water spraying out of the tap sleeve right here.
Okay.
So it's from underneath the tap sleeve is where it broke again.
Okay, so the main is above that?
No, the main is connected here. Oh, excuse me.
Can I assist?
Okay, hang on. Please state your name and address for the record
Marie Askin, Principal Professional Engineer for City of Minneapolis.
for the water department, correct? Okay. Marie, correct?
Correct.
Thank you. Marie, would you like to comment on this as well?
Yes. In the City of Minneapolis, the resident or property owner owns their service line all the way in through the connection to the city water main. The city solely owns the water main itself. If the tap connection to the water main were to break, is still the responsibility of the property owner.
And that's how you've handled claims of this nature and others?
That is how it's always been handled, and that's per city ordinance as well.
Okay, and perhaps you could just flip the city ordinance, so, one more time, the other direction. One more time.
One more time.
Perfect, keep going, yeah, exactly, okay. Okay, so I just want to ask, because Mr. Purdy had brought this up, that sometimes we just kind of negotiate a settlement when something happens on the private side of it. Are you familiar with anything like that?
No, the only time we've ever had any discussion over it is when there was a problem with the main as the source of the problem. When the source is on the private side of things, it's very clear in ordinance what we have to do.
Okay, are there questions for Mike or Marie? Councilmember Quincy.
Thank you, Madam Chair. My question is about the performance of the work, because part of the claim, I'm assuming, is about the labor cost of that. What role did the city play in repairing this leak or fixing it?
Well, a private contractor dug the leak and removed the manhole. The city came in to install a new tap and cut the piece of main out that was broken and installed a new tap into that. And then the manhole was reset by the private contractor, a new manhole.
Thank you.
Is there anything they can do to prevent this from happening again? So they've had 2 times that this has happened. Is there anything you can comment on in that regard?
Yes, at the time of the first leak, that manhole should have been repaired. That was the cause in the leak in 2001 and again, the present situation. And if it had been repaired properly such that it was no longer pushing down, the manhole was no longer pushing on the city main, that would have not happened.
Okay. Further questions for Mike or Marie? Okay, thank you very much for your testimony. Mr. Purdy, I'm going to invite you to come back up again and comment on what you heard from the city staff.
Thank you, Madam Chair and members of the committee. We were not involved in 2001 at all. We were never notified that there was a leak in 2001 and were not involved in any repairs at that time. The second point that we would like to make is that our expert, LVP Plumbing, who does all of our work, had noticed us that about a year and a half ago, there was a major leak between 10th and 11th Street. And there is some belief that the cause of any settlement in our manhole and of the saddle component piece as well as the main line may have been from that particular flood a year and a half earlier that had the main subside from its prior position. We're not absolutely certain of that position. We're simply saying that that's one very plausible theory as to why there is a slip in what is the connection to the main. So those are our additional comments.
Okay, thank you. Further comments or questions? Mr. Scarda, do you have anything to add here?
No, I don't. Thank you.
Okay, we'll close the public hearing. Councilmember Quincy.
Thank you, Madam Chair. I think I'd like to move to deny the claim.
Okay, anyone else have further comments or questions? I guess what I would say is we need to hear from our staff that the city was negligent, that we didn't do something that caused this problem. And I tried to get some information out there and give you some direction to try to explain that, but it sounds like this is a fairly cut and dry case. It's terrible what happens in my ward. I'm very familiar with the location. It's a disruption of water to some really great businesses. But in the end, if every time a water main broke and the city was negligent, we'd have a much bigger problem on our hands. In this case, I don't think the city was negligent. On Councilmember Quincy's, I'm sorry, Councilmember Glidden.
Thanks, Madam Chair. And I think you just had one little turn of phrase, and I just wanted to maybe just make a correction. We don't necessarily need to hear from our city staff that they believe there is negligence, but we need to see it in the evidence presented to us. And I think Councilmember Goodman did make that point as she was further describing what we would look for. But that is what we need to see here today in the presentations that come forward. So thank you.
Thanks for clarifying that too. On Councilmember Quincy's motion, all in favor signify by saying aye.
Aye.
Any opposed? That item has been denied. I will note that there is a conciliation court process. Everyone knows that. And you can move on to the next level if you so choose. We'll move then on to item number 2, Damon Dunkel, 5152 Lindale Avenue South. We'll start with Mr. Scarda.
Thank you. Madam Chair, members of the committee, this is a claim brought by Damon Dunkel with a date of loss of January 26, 2013 in the amount of $10,496.72 related to a sewer backup. Mr. Dunkel filed the claim for property damage. He indicated that on January 26, 2013, the city improperly installed a non-insulated sanitary manhole cover cap, which caused his lateral line from his house to the sanitary sewer to freeze, resulting in a sewage the the investigation and the information presented to the Claims Committee indicated that there weren't or there were limited options regarding installation of sewer or manhole covers, and that actually this lateral line to the claimant's house came in higher than usual into the manhole, into the sewer system. And the lateral line was installed by a private vendor in 2001 and was not installed by the city. So the decision of the Staff Claims Committee was that the private contractor had installed the lateral line too high into the manhole, which resulted in the system freezing and the sewage backup into his property.
Okay, are there any questions for Mr. Scarda on item number 2? Seeing none, we'll open the public hearing on item number 2 and ask Mr. Dunkel if he'd like to come forward.
Thank you, Madam Chair, committee members. So just a couple notes on the claim as it was described, and then I'll provide a little bit more context to give you a little bit more sense, and then some photos, hopefully that'll illustrate the scenario a little bit better. So first, just by way of clarification, I didn't claim that the city on or in January put in a manhole cover that caused this. I live on Lindale Avenue South, right at the corner of Minnehaha Parkway, where there's been significant bridge reconstruction work and redevelopment work of that street over the course of the last 3 or 4 years. And so the notion is that at some point during that reconstruction, a cap was put on the sewer, according to the city's own sewer worker who came out, indicated that it was the wrong cap for that installation. In other words, a cap that was put on was a cap to the effect of this, which is a cap that was actually taken off by your own city worker, indicating this is actually what would be intended for the middle of the road, like a storm sewer, lots of water to funnel through and get through, and not what should be put on top of a sewer that would need some insulative properties. To that point, once I found out that there was the backup and saw the damage that had occurred, so give you a sense of what happened, that's a toilet and a bathroom in the lower level, both the toilet and the shower backed up, causing an excessive amount of water to go in through the hallway, ruining an extensive amount of carpet and in a hallway, a living room area, as well as a bedroom. So just to give you a sense of what happened there by way of the loss, and then obviously the mitigation that had to take place. Complete removal of all the carpet, all the pad, trim, and paint repair and the like in the basement. So in terms of the actual, how we found out that it was actually at the street, actually in the manhole, plumber came in, routed the line. The house is relatively new. It was just built in 2002, but they routed the line all the way out to the very end of my line. And once the city worker came out and took the cap off, you'll see that what we found was an extensive amount of freezing. And I don't know if we can, if the technology people can zoom in on that at all.
You can see it.
Okay. But you can see a couple things. Number one, my line does go directly into the manhole itself, right? Not into the line. But, and I don't know what the city's definition is, but you can see the person standing right below there. It isn't more than up to knee height or so where that line drains directly into that manhole. And so this is exactly what happened. An uninsulated multi-hold cover caused the frozen pipe, January, right? About 6 inches or so of that had to be chiseled out so the rest of the pipe could flow, and it immediately obviously opened up and drained through. And again, when the city's own worker indicated that that was the wrong application, that cap should not have been the cap that was installed there, that was on a Saturday that the backup happened. The city was out on Sunday and installed a one-hole cap that was not insulated, but indicated that the next day on Monday, they'd be back to install a cap that was insulated that has no holes, which was done. So from my perspective, the breach of duty was the city knew that that was the wrong cap. It got missed in the process by people during construction, renovations, whatever the case may be, either on Lindale or on the bridge itself, and the loss was a result of that breach.
Okay. Are there any questions for the applicant? Okay, seeing none, I'll let you come back up if you want. We'll ask, let's see, this is a sewer? I was wrong last time before it was water. Someone from the city's water or sewer department. Please step forward and tell us your name, sir.
Good morning, Madam Chair and committee members. I'm Roger Bowl. I'm a foreman with the Public Works Surface Water and Sewer Division.
Go ahead and tell us what happened, if it's different than what Mr. Dunkel said.
Well, what I'm aware of is that,
You could stand straight up, we could hear you.
okay, that cover, the particular cover that had been on there for many years. I've been on this route for 11 years now, and that cover has been there as long as I have been there. And all of a sudden, this claim came in. We don't have insulated covers per se. There is no such thing. All our covers are cast iron, and they either have 1 hole, 7 holes, and now recently we come up with ones that are 0 holes. And we have that whole side of the block with 7-hole covers, and there's never been any incidents there, any freezing whatsoever. And that particular service has been there for, they rerouted that house connection in 2001, and there hasn't been any issues with it since then. So the resident, the claim as to the wrong cover, I'm not sure why he's claiming that, and I don't really want to speculate on what caused the freeze up, if it was people gone, or if a furnace was just a new furnace was put in, or what, or such. I know there had been construction going on there, and that's really what I'm aware of, the new work that was done on the property.
So there is no such thing as an insulated cover?
No.
All of the other covers on that street are 7-hole covers?
Everything on that particular side was 7-hole covers. And since the incident, we've changed the cover for Mr. Dunkel. And if we have any situations where we have known in the past of very shallow manholes that are within the frost line, then what we'll do is remove the cover and cut a piece of styrofoam and put that down in the manhole to try to conserve heat.
So you've never known there to be a problem in this location? There's been this 7-hole man cover since at least 2000, since 01. Is that correct? So you'd have no way of knowing if there'd be a freeze or not freeze on this one versus any other?
Well, I know that there hasn't been any incidents on this block since 2004 that I know.
That were as a result of freezing because of a 7-hole man cover?
Correct.
Okay. Councilmember Gordon.
So in the staff report we have, they mentioned that Sean from the sewer department came out and stated the wrong manhole cover had been installed. Did we have an opportunity to talk to Sean in the course?
Yes, Sean is here today.
Oh, great. Hello, Sean.
Hello, Madam Chair, members of the committee. I was out there and I was looking for the sanitary manhole. And in this particular case, it was in the boulevard, which isn't, it's not uncommon, but it's not par for the course. So what I was doing is looking for it. I noticed there was a 1-hole sitting out in the street over a storm. There was a 7-holer in the boulevard, and our new policy is we're trying to stop infiltration of water and treating rainwater. So I just switched the covers. The gentleman asked me, why did you do that? And I said, it's the wrong cover. And then he started quizzing me, and I was like, no, it has nothing to do with that. I said it couldn't hurt to have 1 opposed to 7, but the reason is infiltration.
Okay. That was a pretty good explanation. Councilmember Gordon.
Do you think having if the 1 hole had been there, it would have prevented the freezing?
No.
There was also a comment in the report about how high the lateral was put in 2001, that we weren't made aware of that. And I was curious, do people have to get permits to do that kind of work? And also, is the fact that it was so high, I assume, is part of the problem?
Yes, because it was so high and close to the frost line. And as far as permits, it's my understanding, of course, you need one, but that's not my field.
Sure. But that wasn't put in by the city, that was put in by a private company.
Correct.
Thank you.
Further questions for Sean? Seeing none, I'll ask Mr. Dunkel if he'd like to come back up.
Thank you, Madam Chair. Just a couple of things to note, I guess. First of all, there may not be such thing as an insulated cover, the cover itself that comes insulated, but what's in front of my house above here is a cover that is iron that has insulation under that. And I didn't bring any of those photos, but just to draw that point home. And the second thing was when Sean was out, he actually did say that had the appropriate cover, this either one hole or no hole cover, been put on the sewer, this would not have happened. And that was quite specific, which is why I started this claims process to begin with, as opposed to filing it as a claim through my insurance. If I didn't have any indication that this was a city-related issue and just Mother Nature in and of itself and not the result of something that was done improperly, I would have just filed the claim and moved on.
Okay, thank you. Further comments or questions? Mr. Scarda, do you have anything to add?
Nothing to add, Madam Chair.
Okay, I will close the public hearing. Councilmember Glidden.
Thank you, Madam Chair. I appreciate what's been presented, but on the whole of it, I don't see that negligence of the city has been shown, and so I will move to deny this claim.
Further comments or questions on Councilmember Glidden's motion? Seeing none, all in favor signify by saying aye.
Aye.
Any opposed? That item has been denied. Mr. Scarda, on to item number 3.
Madam Chair, members of the committee, this is an appeal brought by Michelle Haddad, a date of loss of July 18, 2013. It involves a towing of a vehicle. The claimant's vehicle was towed for parking where temporary no parking signs were posted. The claimant indicated that the signs were not clearly visible. She also stated that the street was marked to remove debris, which was not done. When the citation was issued, the agent noted that the signs were posted on the day before, 7/17/2013 at 9:36 a.m., and that before the citation was issued, the agent observed 4 signs in the location. And the committee recommended a denial of the claim because the signs were posted more than 24 hours ahead and 4 signs were visible.
Okay, are there questions for Mr. Scarda? Seeing none, Ms. Haddad, please step forward. Hello.
Council members. I don't know if you guys got my pictures, but I brought some more with me.
You could just put, we did, but you could go ahead and put them on the screen. Except for it's upside down. Perfect. Yep, we have that picture as well.
So right here, I'm standing right by one of the signs, and the next sign is right here, posted to a tree. I have a couple other photos too of that if you want. This one's a little bit closer. Again, right there is the only one that you can, right here, it's the only one you can see. Just to compare, when I came to fight the towing ticket, just so you can like have a better idea, this is what was outside of the city council. So there's one there, and you can see them all the way down. So I guess just in my opinion, I don't think that this is very fair, especially because all of the debris, and this one was, the one that I'm standing by right now was in the ground, like totally not visible. This one was posted on a tree, but the rest of them up front here, way up front towards Nicollet, like by the beginning of the block, were also posted on trees, which is fine, but when there's cars parked here, you can't visibly see any. And I think that the rule is that you have to, from your car door, have to see at least 4 signs from your car door for them to tow it. And obviously you cannot see 4 from the car door. This is where the car was parked right here, so.
Are there questions for Ms. Haddad? Thank you for giving us that presentation. Mr. Miller, I believe, is here. Mr. Miller, welcome.
Good morning, Madam Chair and council members. I'm here on behalf of the agent who's out doing street cleaning. So on July 18, 2013, I printed a copy of the officer's log report indicating how many vehicles were parked on the 3400 block of Stevens. At the time of ticketing, there were only 2, Ms. Haddad's vehicle being the second one highlighted in blue. And a typical day on Stevens Avenue, I just kind of grabbed a screenshot of a Google map. There typically is anywhere between 10 and 20 vehicles parked on that block daily, indicating that the other people that normally park there were able to see the signs. And here's a copy of the citation, and there were 4 signs posted. City ordinance requires that there be a minimum of 2 signs posted, and the vehicle has to either drive past it or it has to be visible from the vehicle. We met the 24-hour regulations regarding this ticket and tow.
Are there any questions for Mr. Miller? Ms. Haddad, did you have anything you wanted to add? Okay, I'll close the public hearing. Councilmember Gordon.
Well, I'm going to move denial of this. We've seen a lot of these, and I think the signage gets up, and it's a responsibility for the driver to pay attention, and I don't think we've been negligent.
On Councilmember Gordon's motion to deny, all in favor signify by saying aye.
Aye.
Any opposed? That item has been dispensed with. We'll move on to the next item, which is item number 4, Brenda Harris. Mr. Scarda.
Madam Chair, members of the committee, Brenda Harris brings a claim with a date of loss of January 3rd, 2014 in the amount of $893.51 for damage to the front bumper and underbody of her vehicle. She indicates that she was driving, approaching her alley, coming from Hillside off James. As she approached the apron, she felt a large dip and bump. She immediately checked her car and noticed damage to the bumper, and there were also pieces of her vehicle in the alley. She reported this incident, and what this is it's a ridge of ice that was at the alley entrance. When it was reported, the city took remedial action and sanded and scraped, but it was a recommendation of the committee that this claim, staff committee, that the claim be denied. There was no notice of this particular condition until Ms. Harris called it in, and that there was no indication that the city had created the hazardous condition. It was a result of the normal freeze-thaw cycle in the winter.
Are there any questions for Mr. Scarda on his report? Seeing none, I'll invite Ms. Harris to come up and address the committee.
Yes, there was a lot of snow and ice in the driveway in the alley coming from the street, from the alley to the street of Hillside. There was a couple of big dips that was, as you approach in, that causing from maybe somebody got stuck or a large plow vehicle could be coming through there and stop right at the end of that driveway, causing that the ice and stuff to have a dip in the driveway.
Ms. Harris, how is the city negligent if we didn't know about it until you hit it and then you hit
because
it? Because
it's the city fault to have the alleyway cleared after the snow had failed. So.
Okay, but you don't have any other specific, we have to hear that it's been called in, we knew about it and didn't do something, and I don't hear any.
Well, I called in afterwards.
Right.
You know.
But if no one calls, we don't know that.
I don't know that someone had called in or anything. I just believe because after a snow falls, after 24 hours, it is the city fault to come out there and remove the snow in the alleyways so we can be able to come out of our driveway and be able to drive the car. I mean, you guys want us to remove our snow from the sidewalk for people to walk. You guys got to remove the snow from the alley so we can be able to drive to and from or in and out of the alleyway. I was coming from off the street into my driveway, and I'm right at the corner of the alley. So I'm in the first house, so I come in and go right in, and I go in, and my car just drops. And then I look later on and find my pieces out there and broken from underneath my car.
Okay, do you have anything you'd like to add?
I don't know, you have to ask me the question.
Okay, thank you very much for being here today. Who is here from city staff? Mr. Kennedy.
Morning, Madam Chair, members of the committee. Our records show that we don't have any prior notice of this. 311 records don't show any report of this particular alley. There was, as Mr. Scarda mentioned, a 301 case, but it was for slippery streets, and those slippery streets were sanded and plowed, but we were not aware of this particular alley. We have 4,000 alleys in the city, which means 8,000 alley approaches, and it's impossible for us to understand the conditions on all of them or treat them all. These conditions of this alley was probably likely citywide, so we don't believe that we were negligent in this case.
Are there questions for Mr. Kennedy? Seeing none, thank you. Ms. Harris, did you have anything you'd like to add?
I do believe that the city is negligent of not be clearing out the driveway. First, the streets need to be cleared. It's 24 hours, and the alleys is 24 hours. They expect that from us, and I think we expect that for them as well.
Okay, thank you. Further questions, anyone? We'll close the public hearing. Councilmember Reich.
Thank you, Madam Chair. I don't believe the standard before us has been met, and so therefore we'll be moving to deny.
On the motion to deny the claim, all in favor signify by saying aye. Aye. Any opposed? That item has been dispensed with. Then we'll move on. Item number 5 has been postponed, so we'll move on to item number 6. Mr. Scarda.
Madam Chair, members of the committee, this is a claim brought by Jean Labor with a date of loss of April 24, 2014, having to do with the towing of her vehicle. On April 24th, Ms. Labor had her vehicle parked at 3649 Bryant Avenue South and was issued a citation for parking where temporary no parking signs were in place, which resulted in her tow. Ms. Labor claims that there were no signs posted on the date and on her side of the block. The notes from the traffic control agent indicated that signs were posted on April 23rd by 9:05 a.m. and that the agent observed 3 signs at the time of issuing the citation. The Staff Claims Committee recommended denial of the claim.
Are there any questions for Mr. Scarda on item number 6? Seeing none, Ms. Labor, welcome.
Thank you. I am Jean Labor. I reside at 4825 29th Avenue South. At 10:15 a.m. on Thursday, April 24th, I arrived at my destination of the Walker Place residence and proceeded north across the intersection of 37th Street in order to park my Toyota. I was aware that parking is difficult to obtain in this neighborhood, so I was cautious when it appeared that there was parking space available so close to my destination. I was careful to observe all the posted information on the east side of the block of 3600 Bryant Avenue South and determined that there were no posted parking prohibitions. There were 2 other vehicles parked in that location, indicating that I was not alone in concluding that it was safe to park there for the hour and a half that I expected to be visiting. At 11:40, I came out to find that my car was gone. When I called 911 to report that my vehicle had been stolen, I was advised that it had been towed and was at the impound lot. I returned to Walker Place and discovered that 2 other visitors who attended the same lecture that morning and who had parked in that same location had also had their cars towed. We had parked in that same location that morning. We were all very perplexed. We agreed that there were no posted notices of a temporary parking ban on that block. We investigated and found that signs were posted on the other side of the street and on adjacent blocks. But there were none on the block where we parked. I have a picture of that. I had parked here. Here's one of the signs that I observed to determine whether or not it was safe. Note that this block has no green boulevard, so that the usual practice of pounding staked posters in the ground is not possible. A sign might have been attached to the existing permanent snow emergency post, but there was not. Officer Miller will tell you that signs had been posted the previous day. I don't doubt that that was the case. But no fewer than 7 drivers parked their cars on the east side of the 3600 block of Bryant between 10:15 and 10:30 and received citations on that morning. That means that 7 drivers and any associated passengers judged it to be safe. At least 3 of them were senior citizens who were visiting the Walker Place to attend a lecture that morning. 7 visitors searching for a safe place to park either observed no posted parking prohibitions, or they're a bunch of scofflaws and decided that they'd take a chance on having their vehicles towed. I pled my case with the city's risk management office. Their standard for offering relief is based, as yours is, on negligence on the part of city staff. I believe that signs were posted on the previous morning. And I believe that Officer Miller is convinced that he observed those signs when he issued those citations, though I suspect that the signs had been removed. And I can't suggest by whom or when, but I'm willing to consider the possibility that somewhere on that block, perhaps in the front yard of a resident, there were signs posted. However, I believe it is the city's responsibility to ensure that parking bans are posted prominently and conspicuously and are maintained until street sweeping has been completed so that visitors and residents are sufficiently advised. The city failed to advise me and 6 other visitors that parking was prohibited on that block on the morning of April 24th. And I believe that the city is responsible for the cost of towing my vehicle. Thank you.
Thank you. That was very well done. Are there any questions for Ms. Labor? Mr. Miller, welcome.
Madam Chair, council members, I'm speaking on behalf of the agent that issued the ticket, badge 45. She's doing street cleaning this morning and was unable to be here. Being shown is a document that indicates the green highlights are the number of vehicles ticketed on the block that Ms. Labor was parked on.
Can you move that up a little bit so we can, okay, thank you.
And the pink indicates her vehicle. On the citation that the agent issued, it documents on the bottom that there were 3 signs posted at 9:05 the previous day, giving us the 24-hour required notice. And also, this is the list that we do enforcement by. It's the Public Works list of how they post the signs the day before and what time they post them at. The block that Ms. Labor was parked on is line 9, and we look at the stop time as the time that that entire street was, the posting had been completed, and that's time that we document on the citations, telling us that the signs have been posted for a minimum of 24 hours. When the agents issue a citation, they're required to look at each sign posted on the block to verify that the signs are correct, and that they give the day of the week that they're issuing the tickets on. And in this case, when speaking to the agent, she told me that she followed our standard procedure. And in this case, she visually saw 3 signs that were posted when she was out there issuing the ticket at approximately 10:30 in the morning.
Could you go back to the slide with the number of cars that were towed
Yes.
or tagged? So in your opinion, is 7 a lot or a little?
It's probably half of what is normally parked on that block. It's located one block north of, I think it's a 5-story nursing home. And we experience on a typical day, we get complaints of block driveways and other violations in that area. Visitors and workers of the nursing home tend to park a block away because the signs directly across the street from the nursing home, I believe it's a 1-hour zone or a 2-hour zone. So it's limited parking in that area. So it's kind of visitors and employees fighting for parking amongst the residents as well.
So usually there's a lot, and this day 7 would represent a little compared
I
to the
would
total?
estimate probably half of the vehicles that are normally parked there. Typically, the block is half full, and a block typically contains up to 30 vehicles. So I'd say on a typical day, I don't know of every single block in the city, but typically it's about half full. So I would say that typically 15 vehicles are parked there on a daily basis, and in this case, 7 were.
Can you show me on the picture where they would have posted the signs if they weren't able to do so because of a boulevard?
I took a Google screenshot of the block, and I'm assuming by address that Ms. Labor's vehicle is one of the first 3 vehicles on the block. And because of the nature of this block, she's right, there is no boulevard. So the street department will try to attach the signs to poles and also stake them into the boulevard, into the city's portion of the grass on the residential side of the sidewalk, if that makes sense. I would estimate typically there's 5 signs posted on a long block, as we call it. In this case, there were 3 indicating that 2 either fell, blew over, were taken, or who knows what happened to them. But we still have to visually count a minimum of 2 signs, which we did on this block, and we saw 3. The agent, we write a lot of tickets for street cleaning. The agents don't typically remember where each sign was posted. That's why we train them to literally get out of their vehicle, verify that they can see signs, or that a vehicle has to drive past a sign.
Okay. Are there any other questions for Mr. Miller? Councilmember Gordon.
Well, you did cover most of the questions. I did note that all the tows looked like they were from the odd side of the street. And do you think there's any chance that the traffic control officer was looking at signs on the other side of the street and they were actually missing? So far we have nothing verifying that we did have signs up on that side of the street, and we had one picture from the next day when there weren't any. But you're saying the officer, when she said, I saw signs and they were visible, it would have been on the odd side of the street along with where the cars were towed from?
Councilmember Gordon, that is correct. The agents look at the side that they're issuing tickets on. And this particular agent, Badge 45, has been a traffic control agent for over 25 years. And I handle the complaints that come into our office, and I have not had any complaints on this agent regarding missed signs or not looking at signs properly.
Okay, I guess it's she said situation here, and it puts us in a tough situation because there really isn't.
Councilmember Gordon, that's correct.
Evidence.
That is typical with most temporary no parking signs. A lot of times after the operation is completed by the street department, they come out and remove the signs almost immediately. Typically, they start doing that between 10 and 11 a.m. And when people go out to their vehicle where they parked at and their vehicle's gone, they look for signs, and the signs had already been removed by the street department. So it shows them that there were no signs posted. That is probably the biggest issue we hear from the public when they go out and find that their vehicle has been towed.
And I think it's particularly hard when we think it's from a senior citizen residence right there on that street. So I have a lot of sympathy. And then when we have a case articulated so well as we heard today, I'm not going to make this motion.
Further, thank you, Mr. Miller. Ms. LaBorde, did you want to add anything?
I could ask some questions of Officer Miller, but I don't.
Okay. All right. I will move to deny. here's how I think about this. You might be right, but the city has to prove negligence. You have to prove negligence, and they have documentation that essentially shows here's where we posted it and when. And I just see it as you have to prove that we didn't do it, or we purposely didn't do it, or there was some other kind of strange situation. I think you were very articulate, and I think I asked the questions to follow up with your points. Where were they posted? Was this an unusual number? But I can't find negligence. And because this is a precedent-setting situation, we're not going to be able to just say, well, you are very articulate, and we feel really bad, and it's possible it didn't happen. We have to look at the actual proof, and the actual proof is a log that shows both when it happened, and also we have a traffic control officer with a lot of history who doesn't really have any, excuse me, sir? Sir? When it's your turn to speak, you will be allowed to speak.
It's too expensive to purchase it, okay? You gotta think for yourself.
So, Ms. Labor, I do think you did a very good job.
Ain't even.
But in the end, I don't see how the city was negligent, and for that reason, I'm going to have to move to deny. All in favor signify by saying aye.
Aye.
If you'd like to, sure, please come up.
The point of negligence is that the city is not simply responsible for posting those signs. They're responsible for notifying residents, notifying visitors and residents that they may not park there at that time. That notice was not adequate. I don't know where that sign was posted, but it certainly was not visible, and I did not pass it as I parked there, and neither did 6 other parkers. If I may, this system is disproportionately expensive for the benefit and value that it has in cleaning our streets. And I'm a master water steward. I absolutely understand the value of cleaning our streets. But in effect, taxing visitors $138, well, actually $180 when you include the citation, so that that can be accomplished, is far more expensive than the value that we're receiving. And was 7 an excessive number? If you looked at that report that he showed you, that list, that was the only block on that list where 7 vehicles were cited. All the others were 2, 3, or 4. So in my estimation, that indicates that the responsibility to have a sign that's visible from my front seat or that I pass was not met. It's not any one individual's fault, but it is ultimately negligence. And I still believe that the city should be responsible for. Thank you. Thank you for your time.
And thank you for coming down here. I think you made some very interesting points that the city generally should think about when posting for street sweeping. And we have policy people here on various committees. You might note these are all senior members of the council who chair committees, every single one, for that reason, so that we can kind of think about how that plays into our policy. And I appreciate your very respectful discourse today and for taking the time to come down. Item number 7 is going to be a letter appeal. So we will ask Mr. Scarda to outline the case.
Madam Chair, members of the committee, this is a claim brought by James Bussman with a date of loss of February 10, 2014 for $202.16 related to the tire damage and towing. Mr. Bussman filed his claim for vehicle damage. On February 10, 2014, he was driving on the west side of Lake Harriet, heard a loud pop. He indicated that he was by the tennis court. The pop came from a tire hitting a pothole, resulting in damage to his tire. He did not have an exact location, but the investigators contacted 311 and were not successful in finding any other complaints relating to this particular pothole. And the committee recommended denial of the claim based upon fact of lack of notice and the official immunity standard regarding the timing and repair of streets and potholes and the discretionary manner in which the Public Works Department does that work.
Are there any questions for Mr. Scarda on item number 7? I'll just give, just in case Mr. Busman is here, I'll just give him an opportunity to speak, should he be here to say something. Seeing that he's not here based on the fact that the city has official immunity with regard to pothole claims that have not been noticed to us, I'm going to move to deny the appeal. Further comments or questions? Seeing none, all in favor signify by saying aye.
Aye.
Any opposed? That item has been dealt with. Now we have an actual discussion item, which, not that I'm looking for items in committee, but we actually have an item that staff has brought forward with regard to allowing staff to initiate litigation and subrogation claims. And so I'd ask Ellen to come up and just let us know what you're thinking, and we can discuss it and or move forward.
Councilmember Goodman and the rest of the council members, my name is Ellen Velasco Thompson, and I am the Director of Risk Management and Claims. I'm bringing forth to you a resolution for your consideration regarding risk management having the ability with joint agreement with the city attorney's office to actually sue third parties who have damaged city equipment. It could be vehicles, but more than likely, it's like our fixed objects. Those big controllers that they have for the semaphores are like $34,000 each when they get knocked off their platform and damaged to the insides. Also, you know, semaphores, stop signs, some of the barriers that we have to protect items. When there are accidents that occur and we can find out who the driver was, we'll go back customarily to their insurance company to seek reimbursement for those items, which would be labor and replacement, and we present them in an invoice. And we are finding that a lot of entities are assigning it to groups for claims who just normally say no. And we say, listen, we didn't have a moving part in this. You really do owe the city, and it should not be delegated off to city taxpayers to replace very expensive computer technology that regulates the semaphores. And we'll get stalled with them. I have about half a dozen cases sitting on my desk that I am supposed to proceed and get money for the city, but I'm getting stonewalled by the insurance companies who are just saying, no, we will not, because historically, we don't sue. And so we are requesting authority today that you would grant us authority for claims for fixed objects, property objects, or it could be vehicles like a police car that is damaged and it's not our fault, that should be reimbursed, or that we should at least file a lien on some individuals who may not have insurance but have an asset like a house that we could put an attachment on and where we could get a lien so one day when they do sell it, we will get paid. This is asking for a limit of up to 45 grand, which would be, to me, the worst case scenario of demolishing everything on the side corner that may have the electronics of the semaphore, and where risk management would take the responsibility for making sure that the lien is enforced, and that if we have to renew it every 10 years, we will do that by computer diary systems. But we would not move forward unless city attorneys would agree and would be at our side to actually file something in district court, or if it's under the level, in conciliation court. The alternative to these claims not being pursued is that every single year, my boss, the city finance officer, has to come to you and get a write-off for items over 10 grand where we cannot pursue. I hope to diminish that with the help of collaboration of everybody within Treasury, City Finance, the Controller's Office, and city attorneys.
Are there any questions for Ellen on this proposal? I just want to note, I think this is really well thought out. They've talked to me about this in advance. The city attorney's office is in agreement, and I felt we should, everyone, especially senior members of the council, should hear that this is a change, that we would be going after some of these situations, and I'm very supportive. Is there anyone else who has a comment or question? Seeing none, on the staff recommendation to move forward, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. Seeing no further business before us, we are adjourned.